This video is about a number of cases, actually case law, connected to Hague-Visby rules. As we all know, Hague-Visby rules are basically followed by virtually every nation that takes in goods by the sea or that sends in goods by the sea. So a case heard in one nation has an impact on the other nation because it's based on one set of rules, the Hague-Visby rules, valid from 1968. So it's about carriage of goods by the sea. So let's take a look at some of the cases. The first one, don't ask me to pronounce it, some tank shipping, 2016. It's a new case. The case was about fish oil, 2,000 tons of it, transported on board a ship, Acacia. Due to obvious negligence of the ship owner, actually the courier we call it, entire consignment of fish oil was damaged. Now it's a case of how much you have to pay. Now under the Hague and Visby rules, couriers have a higher degree of liability than it was in Hague rules, but Article 4 talks about the situations where the ship can minimize its or reduce its liability, exclude liability. Of course, they have to prove that they were, doing it under due diligence. Of course, it's up to the ship to prove its functions have been according to diligence principles. So the ship here says that their liability is only 54,300 sterling pounds. I mark it as sterling pounds, should be actually that. So special drawing rights marked by the International Monetary Fund. But the particular seller of the particular cargo says now he should be paid 365,000. Now the case was about how the valuation of this particular tonnage, 2,000 tons of it, has to be taken into account. Now, according to Hague-Visby rules, the ship's liability is limited to, per unit is 100 liters. So the ship owner tried to make 1 ton of bulk as 1 unit. So multiplying that, so that technically 2,000 tons, so that means 2,000 units should be 54,300. But of course the court rejected it. Court said that the bulk cannot be calculated in this manner, so the ship had to pay a far higher amount than what originally was planned by the ship owner. So the question of how the valuation is done based on special drawing rights, we call them the SDR. Ideally it's 666 SDR per package, but it's up to the court and the situations to determine what exactly is this particular package, especially when it comes to transporting goods by huge bulk. The court would be left to decide how the valuation should be done. So here it was decided in favor of the seller. The next case, Riverstones Meat Company Limited, Lancashire Shipping Company Limited, 1961 case. So what happened here was, imagine that I'm the ship owner, I'm the courier owner, I get someone else to repair my ship, getting ready for the carriage. So under Hague-Visby rules as well as the Hague rules, it's up to me to make the ship seaworthy before the voyage. So but what has happened later was, when the ship was on voyage carrying goods, the seawater entered the ship and cargo holds and damage a consignment of goods. Now here, when the case was filed, I say I should not be blamed. My repair company should be blamed, not me. But the other court said no. Ship company or the ship owner has a complete liability to make the ship seaworthy. Whether he gives it to someone else to repair, whether he gives it to a third party to repair, that doesn't matter. The liability rests with the owner of the ship. So here the courier was held liable. I put the link of the case also down there for your reference. Let's go for the next case. Svenska Tractor and versus Maritime Agencies, a rather old case. Now according to the Hague rules as well as the Hague Visby rules, a ship is not liable for for containers that's kind of carried on board, or rather on the deck of it. The ship can exclude liability for containers that are carried on the deck. We call it a deck cargo. So in this particular contract, a load of tractors were transported on board the ship. Some would have been under, in the holds, but some were stored on the deck. So one tractor fell overboard. So there, the carrier, the ship, tried to escape liability, telling in our bill of lading, the main document, we clearly said that the whatever is carried on the deck, the ship excludes its liability. But however, the court refused to let the ship company or the courier escape from it. The shipping company was told by the court, look, if you wanted to make you exclude liability for the tractors that are parked on the deck, then you should have told that in the bill of lading itself. Just making a general clause telling we are not liable for deck cargo is no chance for the ship to escape liability. So here the court made the shipping company liable for the damage that happened to the sailor with the the falling overboard of the tractor. But somewhat of a different case is this, but it's a more later case, right? 1969, Encyclopedia Britannica versus Hong Kong producer. A huge consignment of Encyclopedia Britannicas, that means books. This was long before the CDs or the DVDs, so they were books, were transported from UK, obviously, to Japan. Some of these books were in containers and they were stored on the deck, so deck cargo. So during the voyage, due to rough seas, some of the containers were flooded with water, and unfortunately some containers containing Encyclopedia Britannica were also damaged. Then the shipper, Encyclopedia Britannica, demanded compensation from the shipper, the courier or the ship owner. But here again the shipping company utilized the particular clause in the, which is a very common clause that we put in the bill of lading, right? That the ship would not be liable for deck cargo. Now in this case, the court made the shipper rather liable for this loss. The court said you should have informed the ship about, you should specifically ask the ship to store encyclopedias beneath the deck. The fact that you did not do would make you having no right to take legal action against the ship. So two rather odd cases. This was in 1953, where the particular clause, even though the clause was there in the bill of lading for the tractor that fell overboard, the shipping company was made liable. The courts here said shipping company could have specifically mentioned it, telling that they are not liable for the tractors that may get into trouble by storing them on board. But here, 17 years later, the court gave a different ruling with regard to a series of thousands of Encyclopedia Britannicas. There the court said the shipper should have informed, shipper should have made sure that the goods get stored below the deck, which are secure and preventable from any kind of water damage. So there the court said the shipping company cannot be held liable. But I think this case is one that should be taken into account, not this case, because look at the age, 1953. This one is 69. Another one, Pyrene Company Limited versus India Navigation Company Limited. Again, rather old case, 54. there was a fire engine to be loaded on board the ship. While being loaded, the fire engine, we call it the fire tent actually, was damaged when the loading was happening on board the ship. Now, the damage happened before the ship was, you know, landed on the deck of the ship. So while hanging, only the tender or the fire engine was damaged. So there, the sellers demanded the full compensation from the shipping company. You have not done the loading part, so you failed to do that. So now the shipping company argued, now since the tender has not, or the engine has not passed the ship's railing, okay, Hague-Visby rules cannot be used. So it was damaged while hanging rather outside the ship. So for that we can't use the Hague-Visby rules. Normally the Hague-Visby rules or the Hague rules give additional protection to ships, right? It prevents the ship from so many liabilities. Here the seller said this was hanging outside the ship, still you are liable for it, it's your cranes, so you have to pay us full compensation. But in this particular case, remember this is 1954, so before Hague-Visby rules, which came in 1968, the court said no, the loading process also comes under the Hague rules, and this case was heard under the Hague rules. Okay, so so that means Hague rules give very little liability for the carrier or the ship. So the shipping company, not the carrier, could escape liability by paying only 200 as compensation. This one, Royal type of company, Dew Litton versus Kulmerline, 1973, rather new case. So it's about adding machines, mechanical calculators. You may have seen these calculators in old shops and all, right? So they were stored on board inside a container. 350 of these machines are there in couple of packages, but they were damaged while on the voyage. Then the shipper demanded compensation from the ship, the carrier. Now here the question was how the calculation should be made. Now under Hague-Visby rules, this should be Hague-Visby, right? 1973. For package, the compensation that the ship has to be paid is 666.67, right? Technically, special drawing rights, SDR, equivalent to about $2-3 per SDR, right? So that's the maximum compensation possible. So per package, so how many were these packages? There, the court applied what you call as a functional economic test. That means court studied how these adding machines normally get transported on board, right? They were packed early days in wooden containers, wooden crates, carrying a number of about dozen machines each together. So their court made the estimation that you can't make one machine as one package. So the way the ship carries them normally, as a single pallet, we call it a pallet, right? And how many of those pallets are needed for the 350 per each pallet? Yeah, the compensation possible was 666. So that's how they did the calculation. So even today, when goods are being transported, in case of damage to the goods, remember the damage payment that the ship has to pay in case the ship was liable is this much of maximum pay per container or per package. So the size of the package could be a container sometimes, the size of the 20-foot container, depends on the court's decision, right? Or something smaller, as per the normal custom of transporting these particular goods. Standard Electrica, South Africa, right? Hamburg versus whatever, right? 1967. 1 year before Hague-Visby, this should have come under Hague rules. So it's about television tuners to Brazil. But much of the cargo went missing during the voyage. So the carrier, anyway, the ship accepted the liability. But the problem was, how the calculation should be done. Again, right, up to the court to determine how these television tuners were packaged. So per package only, the calculation will be done. And no matter how much the value of an individual package is, the maximum compensation, this was heard under the United States law, right? During that time it was $500 per package. Even if the package has a thousands of dollars value, maximum that the ship has to pay is $500. So in this particular case, the court identified that they were shipped in seven separate pallets, that means packages. So per each package, right, per package, so 500 into 7, 3,500. So that's the maximum that the shipper was able to claim from the ship. These individual television tuners would have been high value, but you can't make the ship pay the full amount of compensation even to date. Valuation is done for the package, and the size of the package determines on the habit or the custom of or the practice of the ships when it comes to carrying this particular cargo. So these are the cases connected to Hague rules, some of them Hague Visby as well. Even if the case law in Sri Lanka comes into play, our case law also will be using these cases heard in other countries, because most of the countries would be hearing shipping related, transportation of goods in ships, right, related cases under one set of international rules coming under the particular convention that created the Hague Visby rules. So catch you in another day.